So obviously, as you guys are aware, we absolutely can't dismiss on the spot. It wouldn't be considered fair process. So even was this is would be considered gross misconduct, and absolutely, it may be seen as unfair, maybe outside of employment law, but gross misconduct dismissals need to follow the same process as all other dismissals. If we don't have a process, so without a process, a dismissal will be deemed unfair, even if the employee has done something bad. So, and instant dismissals on the spot are almost never ever considered fair. So it's really important to remember that even though there might have been really extenuating circumstances, it still wouldn't be deemed fair. So 85% there is really good. I'm actually very impressed with that. Perfect. So here we have the 5 potentially fair reasons for a dismissal. Now, procedures should always be followed, but we're looking at conduct, capability, redundancy, a statutory ban, and then some other substantial reasons. So that's SOSG or SOSR, which would be, I suppose, other kind of extenuating circumstances. Now, we still say for clients, whilst we have fair reasons for dismissal, we would always say call the advice line, call the advisors, get their expertise on it. They will walk you through the process for all one of these. Whilst there is fair reasons, there's still a process involved for everybody involved. And there again, just flagging it, consistency and fairness is key. So consistency means we need to ensure that all employees are treated the same for the same offences. So we can't have one individual receiving a lesser sanction for what could be considered a very similar offence. And we need to ensure that the same procedure is followed for each instance. So investigation procedures, disciplinary procedures, that we have a very, very clear and robust policy, and we're continually following it no matter the individual employee. And I suppose when we're looking at investigations, we're going to be looking at, gathering appropriate evidence, witness statements, and that everything is followed through correctly. Then when we're looking at fairness, we're checking really there to make sure that the same sanctions are being given to the same offences. So this may be in the case of 2 or more people being disciplined for the same offence. It doesn't really matter if we prefer one employee or if one employee, is, favored over the other one. They still have to be treated the same. If not, we're really leaving ourselves open there to cases being brought against the company and claims of grievances, things like that. We really need to be just aware of consistency and fairness when we're looking at our procedures. So when we're looking at the fairness of the procedure, we're going to be checking to see, was it carried out in a fair manner? And have you followed your contractual procedure? So when we're looking at our contractual procedures, this is what's set out in the employment documentation. So what the consultants such as myself and the other guys in the team have drafted for you. So I suppose for our own aspect, the Peninsula documentation is extremely robust and very strong in relation to the policies and procedures. It's very clearly laid out for the staff and for the employer, and whatever is within the documentation, we need to ensure that we're following it exactly to the T, and that we're not picking up any procedural flaws as we go. Is our process and outcome proportionate to the offence? So when we're looking at proportionate, we're going to be looking at things like, maybe if an individual is late on a few occasions, this definitely wouldn't warrant a final warning. Wherever if we were looking at maybe someone being violent in the workplace or things like that, that then would be considered maybe a final warning to give to that person. We wouldn't then be looking at a verbal warning. We need to understand the severity of the incident and then pick an outcome that would be proportionate to that incident. Have we followed a fair and reasonable procedure that has been applied consistently? So when we're looking at consistency, we need to check, have we been consistent with everybody, all the employees across the board? We need to make sure that we haven't shown any favoritism, that we can show that we've followed the same process for everybody else. And I suppose here managers really need to be concerned and just aware that they're not shown to be favoring any employees, and that it is fair for everybody across the board. Okay, so we have a little example here. So here we have a care assistant versus a nursing home. In this instance, the care assistant was seen on CCTV being abusive to a resident. The employer did not follow the fair procedures, and they didn't follow the correct investigation stage. And then that employee brought a case, and in the Employee Appeals Tribunal, the individual was awarded 30,000 for an unfair dismissals claim. So whilst we can see here, this is a fantastic example, the employee arguably was in the wrong. They were being abusive to a resident, but because the employer didn't follow the correct procedures, the employee was awarded there because it is, when we get to take a case, it is 80% kind of policies and procedures, and then 20% is really, I suppose, what actually happened um, in the instance, what we're actually speaking about. So where we're at now, what do we need to do? We need to ensure that policies and procedures have been issued, that dignity and respect at work training should be delivered at least once a year. Um, it's very important as well there to have regular buzz meetings with your team to keep the communication open and set performance explanations or expectations, and then also speak to ourselves, speak to Mandy, and see what we can do for yourselves to ensure that you are in a very good position, that you are protected if anything like this was to come up.